Mr. Stewart, in Sony, Justice Stevens was clear that there was no secondary liability provision in the copyright law. And he relied on the existence of secondary liability in the patent statute and borrowed from that for his argument that there would be secondary liability in copyright. How much should we borrow from either patent law or from common law with respect to in developing our secondary liability jurisprudence under copyright?
I think probably the first place you would look is general principles of aiding and abetting law, which are common law principles. But if the court thinks maybe intellectual property cases are different, it could look to Congress's codification of secondary liability principles in the Patent Act. And it's very clear that in patent cases, the Patent Act doesn't provide for secondary liability in circumstances like these. In the Patent Act in 35 U.S.C. 271B says whoever actively induces infringement of a patent is liable. And Section 271C says anyone who sells a device that is specially suited to patent infringement, not capable of substantial non-infringing uses, with knowledge of its special character, is liable. There's nothing in the Patent Act that says if you sell a multi-use device to a person that you know is going to use it for infringement, you can be liable on that basis. So I think it would be unusual to adopt a special rule of copyright law and ignore the rule of patent law that Congress has actually adopted in the U.S. Code.
Do you read patent law then to be the same as the common law of aiding and abetting?
I think, yes. I mean, I think the patent law, as it's currently codified, incorporates the two bases for secondary liability that the court adopted in Grokster and Sony as principles of copyright law. That is, in Grokster it said the law that one who induces infringement can be held liable was a common law principle before it was codified in 1952, and we adopted here as a principle of copyright law. Similarly, in Sony said we adopt the staple article of commerce doctrine from patent law as a principle of copyright law, that ordinarily if you sell a staple article of commerce, one capable of both infringing and non-infringing uses, you won't be liable for the misuse made by individual customers.